First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. We have two cases scheduled for oral argument this morning. We will proceed in the order in which the cases are set forth on the docket. Our first case scheduled for oral argument this morning is AHFMCO of Florida versus Aka and Simply. We'll allocate 20 minutes per side for the oral argument. Counsel ready to proceed?
Yes, Your Honor.
Counsel, would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes.
So noted, counsel. You may proceed.
May it please the court. My name is Brandis Dixon. I'm with the Pennington Law Firm, and I represent AIDS Healthcare Foundation, doing business as Positive Healthcare. And I would first off like to thank you and your IT department for making remote argument available to us in this time. Your Honors, in this case, the appellant prevailed below by demonstrating to the satisfaction of the administrative law judge that the Agency for Healthcare Administration acted contrary to the ITN's scoring and ranking instructions by doing a piecemeal review of each response to the ITN instead of a holistic review, as was dictated by the ITN. The judge found that Aka's decision to do so was arbitrary and capricious and contrary to competition. He further found that when Aka knew it could not comply with the ITN's scoring and ranking requirement, that Aka made a knowing decision not to issue an addendum notifying the bidders of the change. The ALJ based all of those findings I just recited to you on either the testimony of Aka's own procurement officer or the ITN itself. Despite that evidence, in its final order, however, Aka rejected all of those underlying findings of fact and conclusions of law in paragraphs 89, 100, 142, 143, 144, 145, and recommendation A of the recommended order to reject all bids. And we believe that was in violation of section 120, 57, 1L Florida statutes.
Counsel, how was the appellant harmed by the scoring process employed by Aka?
Thank you for the question, Your Honor. That is what gives us standing to bring this proceeding in the first instance. We were harmed because we've never made it to negotiations. As stated in the ITN, the ultimate rank was what determined who or which bidder was going to make it to negotiations. Because the Aka decided not to conform its scoring and ranking in compliance with the ITN dictate, then we were not given the opportunity to make it to negotiations. So that is the actual harm that was suffered by my client. And getting back to section 120, 57, 1L, the
Counsel, can I ask you a slightly different question? If, let's assume for a moment that your client violated the cone of silence, would that be enough by itself to support Aka's denial of your client's protest?
Thank you for the question, Your Honor. No, it would not. The appellees suggest to this court that it was a departure from the essential requirements of law, that the ALJ failed to consider their cone of silence issue, determining Positive as a non-responsive bidder. And this is their attempt to rewrite history. In point of fact, the ALJ devoted 3 pages in his recommended order to the issue and ruled against them. And the ALJ, in doing so, underscored the agency's overreach and likened it to the administrative state arbitrarily and belatedly taking action against a licensee only when it suits its purposes. Aka vested authority in its procurement officer to declare a bidder ineligible for award for acts known up to the point of making an award. That's in the ITN itself. Here, the procurement officer chose not to do so, and Aka advanced the non-responsiveness theory only when it suited the agency, which was after the protest was filed. This was too late, as noted by the ALJ, in accordance with page 25 of the ITN, and that's in the record at page 5723.
Well, let's dispense for a second with concepts of standing. I mean, let's get rid of the labels for a second and just talk reality. Are you saying that if Aka knew, looking at the protest petition, that based on facts that suggest that your client violated the cone of silence, that Aka would still have to redo the process, knowing that it was going to label your client as either non-responsive or perhaps even non-responsible, and disqualify them at the front end. And they'd still have to go through the process knowing that?
Yes, Your Honor, and that's because there was no competitive harm that was shown below. Because the anti-competitive harm requirement would have been the picketing or the protesting that they're talking about, the letter writing, those kinds of things. Those occurred after ACA had already decided that Positive was not going to negotiations.
Well, what was the purpose of contacting or protesting in front of ACA's headquarters or contacting the governor in the first place if it wasn't going to make a difference?
These are things that are outside the record evidence. I know they were proffered by appellees or below, but they were not actually admitted into evidence. And the judge considered the assertion that the cone of silence violation had occurred, but then turned it back on ACA and said, you had all this information before you prior even to sending this case to DOA, and you decided not to take action on it. So that rightly cannot be visited upon Positive at this point. In essence, the agency already exercised its discretion by not doing anything about the picketing or the letter writing.
Could
If I
ACA
may
go ahead.
Go ahead,
Sorry.
Counsel.
No, sorry, Judge.
If I might digress for a moment back to my initial question, wasn't Ms. Stidman unable to point to anything specific in appellant's proposal that would have been written differently had the appellant been aware of the scoring process that ACA actually used?
Thank you for the question. So this is the testimony of Donna Stidham. She was Positive's agency or Positive's representative at the final hearing, and she testified, and this was uncontroverted, that had Positive known that this was not going to be a holistic review, that this was going to be a review by SRC in a vacuum, that Positive would have put in every single response. It would have put in the mode of care, the plan flow in every single response. That testimony was uncontroverted, and that is what in paragraph 100 of the recommended order, the ALJ found was the harm to Positive. Because if you're looking at an application in context and you believe it's going to be a holistic review, there would be no need to reiterate for every single question what you had already put in the first sections of your application. We liken this to if your son or daughter applied to college and your son or daughter is the captain of a varsity team, there's a lot of time taken of his or her extracurricular activity time, and they also made phenomenal test scores and grades, and you're told this is going to be a holistic view of your child's application, there would be no reason for you to keep reminding the reviewer, by the way, my child scored these great, amazing grades and scores in addition to being the captain of a sports team. It doesn't make sense. You would not have to repeat yourself over and over and over again.
In this case, though, is there any evidence of record that Positive would have been in the top two spots had the scoring method outlined in the ITN been followed?
There is no evidence in the record, and that is precisely why we brought the protest, was because the decision by ACA to not follow its scoring and ranking rubric as announced in the ITN deprived Positive of ever being able to demonstrate to the ALJ that the ranking would have been different, because there was no scoring of all end-to-end or holistic scoring such that any reviewer's scores could then be dissected or reweighed in order to get to an apples-to-apples comparison. That's the entire point of what the ALJ found in his recommended order.
Counsel, I don't want to. Sorry to dwell so much on the protesting aspect or the cone of silence aspect, but I wanted to come back to that. What process would ACA have to go through? Let's say that you were successful and you got the process started over again, and ACA, knowing assuming ACA reached the conclusion that your client had violated the cone of silence. Is there some special process you're saying that ACA would have to go through to disqualify your client at the front end of the process and declare that the petition was or the submission was disqualified or non-responsive, non-responsible, anything like that, or is it agency discretion?
No, Your Honor. So the process is spelled out on page 5723 of the record, and this is part of the ITN at page 25. And it states that the procurement officer may rely on any facts available to make a determination at any time prior to award as to whether a vendor is a responsible vendor. So there is a temporal relationship between what the agency knows and its decision to act on that knowledge. And the time for the agency to act would be before award is made. In this case, the agency did not raise this issue with positive until after it filed its protest, which the ALJ found was too late. In essence, the ALJ had already found that the agency had exercised its discretion to do nothing. And
Right,
only.
go ahead, finish your, I'm sorry.
I'm sorry, it's difficult. And only and only when it served the agency's purposes, only when it suited its purposes to find positive non-responsive did it raise the issue. And that's why the ALJ determined that the agency cannot simply pull this rabbit out of the hat beyond the time to do so, because it's akin to telling a licensee, well, we know we brought this administrative complaint against you, but we're getting to the hearing now and we're going to file some additional charges against you. It's a due process violation. There's no warning to the bidder in this case that this was going to happen. In fact, all evidence pointed to the contrary. ACA decided to send this case to DOA for a formal administrative hearing. ACA could have said, wait a second, we're not sending this to a hearing. You're non-responsive. It chose not to do that. It waited. In fact, it waived the issue. And that's what the ALJ found.
Well, instead of I want to move you forward on the timeline into the, I guess, the future or the hypothetical future. So the secretary signs this final order and, dismisses the petition. But let's say, could the secretary, instead of dismissing it for lack of standing or some jurisdictional issue, said, well, I'm going to deny the petition because I know now, based on the findings in the ALJ's recommended order and the evidence that's in the record, that your client violated the cone of silence. And I know that if I started the process over again, if I granted the petition, they're going to be disqualified at the front anyway. So it'd be futile to do this. So I'm just going to deny the petition. Are you saying that the secretary cannot do that?
What I'm saying is the Siobhan Harris is already on record. She was the agency representative on this issue. And she said that there is no intention to disqualify positive from any future bid. She said that. She said in fact, that would be more akin to putting a bidder on a no bid list. That's not what happened here. That's not what happened here at all. There is no, other than the irresponsible bidder list, there's no way to keep a bidder from bidding on an ITN or an RFP. That would be the ultimate contrary to competition argument, especially because it was not found by the procurement officer to be an impediment to Positive's response.
Well, Counsel, if I may,
yes, sir.
so surely there's a difference between saying that they're going to be excluded from all future bidding processes versus being prohibited from participating further in this process. Right? I mean, do you distinguish between those two things?
The only distinction I would make is that the agency representative, Ms. Harris, already said that Positive would not be prohibited from making a bid on a future Medicaid management care plan for specialty HIV. So that's I do not think there would be a difference, and I'm relying on her word. So I do not know how to answer that other than to revert back to what Ms. Harris testified.
Counsel, let me be specific. Let's assume for the sake of argument that the final order on appeal is reversed. In this case, could the agency still deny your bid or your proposal based on the cone of silence?
I believe they're foreclosed from having done that because they did not make a finding of non-responsiveness below. They're actually asking this court to make a finding of non-responsiveness. The record is what it is at this point. The only decision that this court has before it to make is whether the agency had the authority to reject or modify the findings of fact or the conclusions of law that were put into the recommended order by the ALJ. And that's the scope of the review at this point. So because there were competent, substantial evidence in the record to support each and every one of the ALJ's findings. In fact, they were the testimony of ACCA's own witness, Ms. Barrett, and the ITN itself. ACCA cannot do what it did. It's in violation of 12057-1L Florida statutes.
Regarding the substantive jurisdiction argument, why shouldn't ACCA be deemed to have substantive jurisdiction over the issue of standing?
Thank you for the question. It should not. No state agency has substantive jurisdiction over general concepts of law. That's just not how the APA works. This was put to rest, I believe. I put this in the reply brief as to why the agency cannot do what it did. In the Lawnwood Medical Center case, in Lawnwood, the ALJ concluded after a formal administrative hearing that a CON criteria favored one vendor over the other, and the agency upended the recommended order and said, well, we have substantive jurisdiction over the entirety of the CON process. So any protest that is made under this CON protest rubric, we can decide the outcome of it irrespective of what the ALJ decided at DOA. And this court said that's not the case at all. ACCA cannot recast findings of fact as policy questions, is what this court said. And the agency cannot reject a hearing officer's findings of fact by treating the issue as one of policy. Rather, the agency's function is to apply its policy to the facts, which are supported by competent, substantial evidence. And again, that's the Lawnwood Medical Center case, 678 Southern 2nd 421, decided by this court, and it has not been overturned.
Counsel, you also cite the Cappelletti Brothers case as well in support of your argument. But isn't your reliance on our decision in Cappelletti Brothers misplaced, since what you cite in support of your standing argument was dicta in Cappelletti Brothers?
Okay, thank you for the question, Your Honor. And this, the positive standing to seek a rejection of all bids comes from the fundamentally flawed nature of ACCA's decision to eschew its scoring and ranking rubric found in the ITN. And there is a host of case law post Cappelletti that gives positive standing. And this was cited by the ALJ. This is the Vertex case that he cited. So in addition to Cappelletti, Vertex states that this is the type of injury that 12057 proceedings are designed to protect.
Does it make a difference that there were only two bidders in Cappelletti where there were more than two in this case?
I'm sorry, Your Honor.
Does it make a difference that there were only two bidders in Cappelletti Brothers case versus this case which had more than two?
It doesn't make a difference one way or the other. Our positive standing derives from the fact that ACCA's procurement was fundamentally flawed. At the time, it decided not to either issue an addendum to the ITN to let bidders know that scoring and evaluation was not going to take place how the ITN had said, or to come into compliance with the ITN and have an end-to-end or a holistic review of each of the responses to the ITN.
If we agree with you that ACCA erred in dismissing your protest due to lack of standing, what in your opinion, is the proper disposition in this appeal?
In this appeal, this court's jurisdiction to fashion a remedy is broad, according to 12068. This court can do anything that it decides to do to address what occurred below. In this instance, Positive would seek a rejection of all the bids for just the specialty HIV plan for regions 10 and 11. We're not seeking a rejection of all the bids or a redo of any of the other regions or for any other plan type. It's just the HIV specialty plan type for regions 10 and 11. In addition, we have a pending motion for attorney's fees. So we would also, in addition to the remand back to the agency to follow or reinstitute the recommended order with regard to recommendation A of the ALJ, we would ask for this court to award attorney's fees.
Thank you, counsel.
Thank you.
Your time has expired. Counsel for appellee, ready to proceed?
Yes, sir. Yes, Judge.
I understand you split your time. You're arguing 14 minutes and counsel for simple is arguing 6 minutes. Is that correct?
Yes, it is, Judge.
So noted. You may proceed, counsel.
Thank you, and may it please the court, I'm Daniel Nordby on behalf of the Agency for Healthcare Administration. I will be splitting my time with counsel for Simply Healthcare Plans, the winning bidder, and ACA's current HIV/AIDS specialty plan contractor in regions 10 and 11. Unless the court would prefer otherwise, I'd like to focus my limited time on the threshold issue of standing, which we would submit is dispositive of this appeal. And it's a subject that this court has already addressed with my friend on the other side. It is a black
Regarding
letter.
that point, counsel, how does ACA have substance jurisdiction over the issue of standing?
Thank you for the question, Judge Lewis. I'd like to answer it in two ways. One, a direct answer to your question. And then the second is suggesting that the answer to the question ultimately doesn't make a difference. So first, the direct answer to your question is that an agency does have substantive jurisdiction over the question of standing in a circumstance like this. The conclusions of law that are addressed here involve the interpretation of the ITN and ACA's implementation of statewide Medicaid managed care under Part 4 of Chapter 409 of the Florida statutes. Those are policy-infused matters within ACA's substantive jurisdiction. But ultimately, the issue of standing is reviewed by this court de novo. This court confirmed that in the Best Care decision issued earlier this year, a case that arose out of this same Medicaid managed care procurement, and Judge Lewis, the case in which you participated. This court held that the issue of standing is reviewed de novo by the appellate court. So whether ACA had rejected and changed the ALJ's conclusions of law on the issue of standing or not, it would be presented to this court as a de novo issue. And as a de novo issue, standing is a matter that, as a matter of black letter law, requires a bidder protesting a contracting award to demonstrate that it would be entitled to the award of the contract if successful in its protest.
Well, counsel, in terms of black letter law, that's not in the statute, right? I mean, that phrase that you just read is not in the statute. Would you agree with that?
Judge Tannenbaum, the statute refers to a person who is adversely affected by the agency decision having the ability to file a notice of protest. And what cases going back to Preston Carroll from the 3rd District in 1981, the 5th District's decision in Madison Highlands, and then this court's decision in Best Care have all interpreted adversely affected to require is a showing by a protesting party that they would be entitled to a contract award if successful in their protest. That's simply not the case here for at least 3 different reasons. Positive has not shown that they would be entitled to a contract award here, even in the event that they were successful in their protest. Now, they've latched on to this fundamentally flawed phrase, which is also not present anywhere in the Administrative Procedure Act. That's a phrase and a concept that comes out of the Cappelletti brothers decision that Judge Lewis referred to from 1981 from this court. But this court just 3 years later in the Westinghouse versus JTA case, which we've cited, disclaimed the idea that the Cappelletti brothers case had any holding related to standing. In fact, the Cappelletti brothers case says in its footnote explicitly, footnote 1 of that case says, although not raised by any party, it appears that Cappelletti Brothers has standing to raise this sort of challenge. Every other case that Positive cites for this idea that a bidder who can't show they'd be entitled to a contract award can seek or reject all ultimately relies on that Cappelletti Brothers dicta. Every other case they've cited is a handful of DOA decisions that all go back to Cappelletti or cases relying explicitly on Cappelletti. So
Well,
that
counsel, the problem with Westinghouse, though, on which you rely, is that in Westinghouse, the protester didn't bid, and they were challenging the outcome of a bidding process in which they did not participate. So I'm not sure how Westinghouse helps you any more than Cappelletti, if that's dicta. And so I'm curious, instead, if you just look at the statute, if the statute says someone who is adversely affected by the process or the decision may file a petition, that's what the statute says. In this instance, the Positive is not necessarily just their challenge wasn't to just the outcome or the of the two that had participated in the negotiation. They were challenging the entire process, and that ACA didn't follow the ITN terms. Why is and Positive did participate in that process? They submitted a response to the ITN. Why is that not enough to establish adversely affected for purposes of the statute?
Well, Judge Tannenbaum, we rely on Westinghouse almost entirely for the purposes of rebutting their reliance on Cappelletti Brothers. Our primary basis is on the statute itself and the cases interpreting that statute. It is an issue in almost every procurement. There's an allegation in a bid protest that an agency did not comply with some term of the specification. If that were sufficient to establish standing without demonstrating adverse impacts, simply an allegation that an agency did not follow some aspect of the specification, then it would eliminate the standing requirement entirely, because almost any protester will make that allegation in its petition. Here, the facts show that Positive did not score so low because they were treated differently from another bidder, because the allegations that they've made about ACA's implementation of this procurement had a bias against Positive. Positive scored low in this procurement on the record here because they didn't comply with the procurement specifications. They did not provide the HEDIS data set that constituted a significant part of the scoring. They did not respond at all to several of the submission requirement components, the SRCs of this procurement. My friend on the other side said that they expected ACA to go back and forth and cross-reference all of their prior responses to put it in the context for each of the responses. But at page 5,761 of the record, the ITN specifications specifically say that respondents shall not include cross-references between the SRCs, that the evaluators will be instructed to evaluate the responses, quote, based on the narrative contained in the SRC form fields, not holistically by cross-reference to answers to other questions.
Counsel, regarding your argument, under what circumstances would a losing bidder have standing to claim that the bidding process was fundamentally flawed?
Judge Lewis, the showing in any protest under 120.57.3 should be that the party can show that they would be adversely affected by the agency's decision. And that requires a showing that not only that there was an alleged flaw in the process, but for that flaw, the protesting party would have been entitled to a contract award. Or perhaps in the case of an ITN, that they would have been entitled to advance to a negotiation stage. That isn't the case here, and Positive didn't make that showing. The evaluators here scored Positive last in Region 11 and unanimously. Every evaluator scored Positive last in Region 11. In Region 10, it was ranked last by 7 of the evaluators and third by the remaining evaluators. ACA was negotiating with the top 2 in each region. So in one region, it scored third. In one region, it scored fourth. Under any showing here, Positive has not made any kind of showing that but for these alleged errors by ACA, it would have been invited to negotiations.
Isn't that more of a harmless error type of analysis? And why can't why can't ACA or any agency, instead of focusing on like this standing idea, which really is not in the statute's terms, why isn't an agency not free to consider a petition, look at the evidence, and conclude, well, there may have been a mistake, but it's not going to make a difference in this case, so we're not going to grant the petition, just like courts do. I mean, why can't that be part of the analysis instead of front-loading a merits-based analysis into a threshold question of standing?
It's an interesting question, Judge Tannenbaum. I think former Professor Dorr at FSU had a very good article back in the 1990s about standing in administrative proceedings and maybe going closer to the statutory language than some of the federal case law that's come out of that. I think it is the case that the purpose of procurement is ultimately to ensure a process with integrity that is fair and impartial to all of the bidders. So perhaps in the concept of adversely affected, by requiring a bidder to show that an error was harmful to them, that it was not a harmless error, would allow that idea or that concept to play out in these bid protest decisions. I think it's also a different question at the threshold stage. For example, in this case, ACA filed a motion to dismiss the petition for lack of standing. That's a different question than it is here on appeal after Positive has had a chance to make an evidentiary showing at the trial. Even after that evidentiary showing, they can't point to any way in which the allegations that ACA did not follow the process outlined in the specifications impacted or harmed Positive based on the scoring issues. And that's even setting aside the cone of silence issues, which I'd like to address.
On the issue of standing, would you agree that a determination of standing is normally a quasi-judicial or judicial determination?
Judge Lewis, could you repeat the question?
Regarding standing, would you agree that the determination of standing is, generally speaking, a quasi-judicial or judicial determination?
Judge Lewis, it's a legal conclusion based on a set of facts. It's an issue that courts certainly do address, but in the case of administrative proceedings under the APA, the agency, when it gets an order back from DOA, acts in a quasi-judicial role to some degree, and deciding whether or not to accept or reject the conclusions of law within its substantive jurisdiction. So I'd like to address the cone of silence issues if I could for a second, because Positive has taken what I think is a novel and rather remarkable view of the cone of silence provisions.
But regarding your cone of silence argument, what authority supports your argument that a cone of silence violation will prevent a bidder from filing a bid protest or participating in a rebid?
Judge Lewis, 287.57 subsection 23 provides that cone of silence requirement and states that violation of the provision may be grounds for rejecting a response. What Positive has alleged in this case is a temporal requirement that is nowhere in the text of the statute, that ACA would be required to reject their bid on the basis of a cone of silence violation, but can only do it up until the time that the award is given. Now, think through the implications of that. If a cone of silence violation first came out in deposition testimony during a bid protest, under Positive's view of what the statute requires, that would be an insufficient basis for the agency or the ALJ to deem that bid as one that should be rejected. They've also alleged that anti-competitive harm is required here. In other words, as long as the agency wasn't going to give it to us anyway, we can violate the cone of silence and there's no consequence for it. Only if we get the award and then we're caught in a cone of silence violation does that statute have any meaning at all. That's contrary to the entire purpose of Chapter 287 and the integrity of the bidding process. It doesn't find any support in the case law. And I think even though the ALJ here rejected the proffered evidence, I don't believe that there's any dispute, even in the initial brief from Positive, as to exactly what occurred here. The contacts that were made to the executive branch officials before the close of the 72-hour period after the notice of intended contract award. And that's a separate and independent basis for finding this bid as one that should be rejected.
Well, counsel, what about the, so your opposing counsel noted, the statement in the record, which I'm sure you're aware of, that the ACA representative had said that, well, this was not non-responsive and would not render positive ineligible in a rebid. Is that preclusive in any way, or should we ignore that? What's your position on that?
Judge Tannenbaum, I don't think that's preclusive. That was a deposition of a non-attorney agency representative. I believe shortly before that answer was given, she said something like, "I'm not a lawyer. I'm probably not the best person to answer that question." In addition to that, page 357 of the record, the actual referral to DOA in this case specifically reserved ACA's right to make motions, to make objections, and ACA promptly did so after this case was referred to DOA. I believe it was only 10 days after it was referred to DOA that ACA filed its motion to dismiss the case for lack of standing. That sort of statement should not be legally preclusive of ACA's ability to make this.
And is it fair to say, or is it your position, I'm assuming it probably is, but I'll ask it, that the ACA secretary, when considering the final order and whether to enter final orders, the secretary have the discretion to conclude on the evidence or the record in front of him that that this bidder or respondent is likely to be a disqualified in a rebid, and just deny the petition at the front end instead of going through the process again?
Judge Tannenbaum, the ACA secretary has the ability, based on the record evidence, to make legal conclusions within ACA's substantive jurisdiction. Cannot open up the record and take new evidence, as was the case in the Lawnwood case that Ms. Dixon mentioned, but based on the record evidence can make conclusions of law decisions like that. I see him cutting into Mr. Rex time.
One final question for you, Counselor, before you sit down. Assume, for the sake of argument, that we agree with positive that ACA erred in its standing determination. What, in your opinion, is the proper disposition in this appeal?
Judge Lewis, if the court were to determine that ACA erred on its standing determination, then ACA would ask the court to affirm on the merits, that positive did not prove its case on the merits and should not be entitled to a rejection of the bids.
Thank you, Counsel.
Thank you, Judge.
Counsel, in view of our questions for Mr. Norby, we will extend the appellee's time by an additional minute. We'll also extend the appellant's rebuttal time by an additional minute. You may proceed, Counsel.
Thank you, Your Honor. And I don't want to retread the same ground. I certainly agree with the points that Mr. Norby made, but I do want to follow up as it relates to the standing question. And I think it was a question that you asked, Judge Tannenbaum, about the statute itself, and in particular, the adversely affected language and how that applies here. And I think it's clear to say that a protester, in this case, obviously positive, that they cannot say that they were adversely affected if they can't establish that they would have prevailed or that they wouldn't have prevailed, whether the error that they're alleging here occurred or not. And that's what you have here, is an utter lack of evidence by positive that regardless of whether the error happened, that they would have proceeded or scored high enough to be within the competitive range to proceed to negotiations. In fact, the evidence below is squarely to the contrary. For example, April Bossons testified, and her testimony was uncontroverted. Positive did not put on any testimony on a rescoring analysis, if you will.
Counsel, regarding Ms. Bosson's testimony, the ALJ, in discussing the Hemophilia Health Services Incorporated case, noted that this case was different from Hemophilia Health Services Incorporated because the unusual circumstances of the agency not conforming to its ITN makes it impossible to determine what the outcome would have been, as Ms. Bossons acknowledged. How do you respond to that finding?
So I would respond in a couple of ways. The first is that That finding by the ALJ is really a legal conclusion based upon a misinterpretation of a legal document, the ITN. The ALJ's finding was that the ITN required that each response be evaluated in total by the same evaluators. That language simply does not exist. That requirement does not exist in the ITN anywhere. The ALJ did not point to any because none exist, and that is, just a square legal issue. The interpretation of a contract, an ITN, a statute, that courts do not read provisions into it that don't exist. But I would also say that from a factual perspective, in a review of the record, it's clear that even if the same reviewers or evaluators reviewed the entire ITN of Positive still would not have scored within the competitive range. We know that for a number of reasons. We know that from some of the scenarios that Ms. Boston's ran. For example, she did a hypothetical scenario, a rescoring analysis, where Positive was awarded every point, all points that were available for every SRC that they raised an issue about before the ALJ, and Positive still did not score high enough to be within the competitive range. And what's interesting is when you look at the SRCs, and in particular the SRCs that had the highest point values, for example, the HEDIS data that Mr. Norby talked about, those are not subjective scores. And what I mean by that is HEDIS data is a numerical measurement that the bidders put into a spreadsheet, and that spreadsheet contained a formula that populated with scores. So whether it was the same reviewers scoring those portions, it wouldn't make any difference. The same is true with the CAPS data. Those scores or the points and weight allotted to those were so much that it wouldn't make a difference if the same evaluators evaluated each of these proposals. I also want to touch on two additional issues. One, Ms. Dixon pointed out, as it relates to the cone of silence, the language, and I think it was on page 25 of the ITN, about the information the agency can rely upon to make a responsiveness determination. And Ms. Dixon read into that provision a temporal requirement that doesn't exist. That provision only speaks to the information that the agency can rely on to make a responsible or responsive determination. And the final thing I want to leave you with, because Ms. Dixon touched on it, is the available remedy here. This court and every other court I'm aware of that's touched on the issue has said that where a contract has not been stayed, and here we've been performing, simply has been performing for an extended period of time, that the remedy is ancillary relief, which would be merely bid preparation costs, not the overturning of Simply's contract. I see my time's expired. Thank you.
Thank you, counsel.
Your Honors, if I may, Mr. Rectus made an assertion that the page 25 with regard to the procurement officer's authority regarding a cone of silence violation is not temporal. I will read it directly to you. It says the procurement officer may rely on any facts available to make a determination at any time prior to award as to whether a vendor is a responsible vendor. So the temporal question has been put to rest. The agency had all the information against Positive with regard to a cone of silence violation prior to this case being sent to DOA for a formal administrative hearing. So there's some slippery slope arguments being made by Mr. Norby about, well, this is going to lead to vendors doing all sorts of nefarious activities. That's not what we have at this case at bar. What we have is the agency already having decided this was not a cone of silence violation upon which we want to act. it made that decision. That ACA is now unhappy with its procurement officer's decision cannot be visited upon positive. Likewise, I heard both Mr. Norby and Mr. Reck state that it's Positive's fault for not being able to demonstrate to the satisfaction of the ALJ, to ACA, to this court, that it would have ranked higher. That cannot be visited upon positive. ACA made the decision to make it impossible for anybody to know how any evaluator reviewing any response end to end would have scored it. That's why the ALJ said Ms. Bosen's testimony is not to be given credence. There's no way to make an apples to apples comparison. That is a finding of fact that cannot be displaced. And I heard opposing counsel, so maybe it's a conclusion of law. Either way you slice it, either if it's a finding of fact or it's a conclusion of law, ACA does not have the authority to reject or modify that finding of fact or conclusion of law. And that's the basis of positive.
Counsel, what about the counsel had mentioned that the record shows that even if you got all the points possible, that you still wouldn't prevail or be one of the top two. And on top of that, you know, in the record, it shows that there were a couple of sections, I guess, where there weren't responses or something like that. So assume it's a harmless error analysis as opposed to a standing analysis. How is it that your client would ever prevail in the first place on this record?
Thank you, Your Honor. So the analysis stems from whether Positive was substantially affected. It was affected because it submitted, I know you've seen all of these responses. They were thousands of pages, and I understand the agency had a lot to digest. But from the bidder's perspective, the thousands of pages it's sending into the agency for review, those were going to be considered end-to-end in a holistic manner. And there's no way to know at this point, despite Ms. Bosen's testimony, if all points assigned were given to Positive, how it would have ranked. There's just simply no way to know that, because what they're trying to do is get into a situation that never happened. The evaluators were not given the opportunity to review Positive's end to end. And if they had, they would have seen maybe the information that was missing in one question was found in another. It's just something that never happened. And the record shows that. So to try to visit upon Positive, its inability to demonstrate to the satisfaction of this court that it would have ranked high enough, it highlights the issue. The issue is the bidders were told this was going to be a holistic review, and it was not at all. And
Counsel, thank you for your respective oral arguments. Your time is more than expired.
Thank you, Your Honor. I thank you.
Thank you each for your respective oral arguments in this case.
Thank you.
Good morning, counsel.
Good morning, Judge.
The case scheduled for oral argument this morning is, excuse my pronunciation, Karalaha versus State. Is counsel ready to proceed?
Yes, Your Honor.
Counsel, we have allocated 15 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
3 minutes, please.
So noted. You may proceed, counsel.
May it please the court. My name is Danielle Jordan. I'm an assistant public defender for the Second Judicial Circuit, and I represent the appellant in this case, Mr. Kojo Kerala. In this case, appellant asked this court to vacate his conviction and sentence for written threats to kill or do bodily injury. Appellant raised two issues in his initial brief, but today I'd like to focus on issue one, which is whether the trial court erred in denying his motion for judgment of acquittal. On June 21st of 2018, an email was received in the jury services portal of the Duval County Clerk's office. That email referenced Judge Mahan. That email was received possibly by Julie Carr, who was an employee of jury services. It was forwarded to Brian Corrigan, who was employee of the clerk's office. It was forwarded by him to Major Weintraub, who was a court security officer, and he brought it to Judge Mahan. And the message was, according to the sender line, sent by my client, Kojo Kerala, and it said, included language, excuse my language here, calling him a low-down bastard, saying, I'm going to come for your no good ass. I'm going to deal with you. I got something for your ass. Go back to the pits of hell. When questioned by law enforcement, my client stated, I didn't mean any harm. I just meant I'm going to pursue you in the court system. I'm going to file a lawsuit against you.
Counsel, would you acknowledge though that so in that conversation, your client did adopt the statement as one that he made in the portal? Would you agree with that at least?
I think that he said he sent a statement. I don't think it was ever identified that this was the statement. I think that it could, there's enough evidence that we're not arguing that this is not his statement for purposes of this argument. Yes.
Is that that's probably also why you're not pursuing issue 2 as much? It sounds like a party admission, or at least adoption by party of a statement, which would make it. That is why we are focusing on issue 1. Yes, Your Honor, that would be the stronger issue by far, and also one that will get my client out of prison. So, fair enough. So counsel, can we just cut to the chase? Is it your position that for it to be a violation of the statute, a statement would have to specify or be identify a body part or the injury that was actually going to be committed or inflicted, or death was actually going to be inflicted? Does it have to be that express?
I think it has to be, to use the reasonable person standard. That is what the courts have used both in Coward and in Smith. I think they use the reasonable person standard only as to part of that, was whether it was a threat, because the question there was it a joke or a threat? They didn't really apply it to the second part, which is a threat to do what? I think the threat has to be clear in some way. It has to use some kind of words that are commonly used in the English language to infer violence. I think there's lots of different threats, and those threats can be ones that would actually raise alarm in reasonable persons. There could be a threat of property damage, a threat of harassment, a threat of embarrassment, a threat of a lawsuit, as my client maintains here. And those would all cause alarm, but they wouldn't meet the statute. The statute requires a threat of death or a threat of bodily injury.
Well, whose call ultimately is that to make? Is it a judge's determination? Are you saying that the courts should make a facial determination whether a particular statement constitutes a threat of bodily injury or death? Or is the better argument or the better position that that's for a jury to decide under the circumstances presented via evidence at trial? I'm sorry, Your Honor. I think if there is absolutely no inference of violence, then I think that's where a judge decides. I think if there is an inference, if there's something like a picture, which could be interpreted in more than one way, then that's something that could go to a jury. But if there's something where there's no inference from the words of violence or of any harm at all, then I think that's a judge decision, because then I think there's no competent substantial evidence. It stops. It doesn't go to the jury. And in this case... couldn't a jury, though, maybe different people could disagree, but that's not the standard for a JOA. Could not the jury, if considering the evidence in the light most favorable to the state, could not a reasonable jury conclude that statements like, I'm going to deal with you and I'm coming for your no good ass, directed to an individual, that could be a threat of violence or a threat of inflicting bodily injury?
I think without more, Judge, no, I don't. I think that there would have to be more. There'd have to be something like we have in all of these other cases where there is a picture of a gun or the use of the word death or the use of the word, I'm going to punch you, I'm going to drag you, I'm going to shoot you, something lethal. I think here the language is really so ambiguous that this would open up really, it would really open us up to all kinds of over-criminalization here. We have freedom of speech that has to be balanced out as well here. And I don't think this is...
What if the statement instead, what if your client, and I'm not saying your client did this, but let's say a hypothetical client or a hypothetical defendant goes to the portal, directs it to Judge Meehan and says, I know where your kids go to school, watch yourself. Would that be a threat that would potentially implicate the statute? Or is that too ambiguous enough to implicate the statute? And it
would be a closer, I think it would be a closer call for sure.
What makes it a closer call for you?
Watch yourself, I think. Well, no, I don't even know that it is. I'm going to have to go back on what I just said. I think that's also ambiguous. I don't think that's enough. The watch yourself what? You know, watch how you're behaving. I think there has to be more. We have to have some kind of confirmation of what's intended here because it's way too open. You can mean anything. You can mean watch yourself, I'm going to be mad at you, or watch yourself, I'm going to talk bad about you, I'm going to embarrass you. It can mean anything. It has to be proven that it's a threat to kill or do bodily injury. I think there's just too much ambiguity there.
So let me ask maybe kind of hone in on this just a bit. So can you tell me what you believe to be the inquiry here? The test, so to speak, of whether or not this is sufficiently a threat. It sounds to me like you're saying it's not, you don't think we should apply a reasonable person standard to this. Can you tell me what standard we should apply?
I think here there was a standard in US v. Callahan, which was whether threatening language reasonably may be construed to evince a serious expression of an intent to do harm. And that was in the Smith case. They used that in coming to their own reasonable person standard. But I think here, in order for there to be a serious of expression of an intent to do harm, there has to actually be an expression of an intent to do harm, not just an expression of, I don't know, some open threat with no intent to do harm. I think that's what's missing.
My point is, if the question is whether a reasonable person could perceive this as a threat, then that's really the question, which is, I think, perhaps a slightly different thing than the way you're characterizing it, that we have to have some special language or some magic word that's included in the statement itself, rather than making an inquiry about whether or not a reasonable person could perceive this statement, whatever it may be, this case or any other case, whether or not a reasonable person could believe the language used in the particular case is a threat, or could be.
I think a reasonable Okay. Yes, Judge. I think a reasonable person, though, while there are no magic words, there are certain words that are commonly understood to convey violence or a threat of violence. And I think a reasonable person would have to accept that those are the words that are missing here. That's, I guess, what I'm saying, not very eloquently, I'm sorry, but those words are missing here. But that is not the only way Mr. Keirala can be successful in court today. Even if this court finds it the threat, it still was not directly sent or directly received by Mr. Keirala.
Regarding that point, counsel, the trial court, as well as the state in its answer brief, relies on this court's opinion in O'Leary versus State. Can you distinguish the O'Leary case?
Yes, Judge, I can. And I think that this court can easily follow O'Leary and my client can still be successful here, because in O'Leary, this court adopted the two-step sending, which was first enunciated in Wise, which is that sending involves the deposit, and it involves the receipt. The direct, it has to be direct. So in O'Leary, Mr. O'Leary posted on Facebook a threat about his cousin, and he posted it to all of his friends. One of his friends was his cousin's relative. So it comports with the statute. In O'Leary, it was sent out to a family member, and it was received by a family member. That is right under the language of the statute, and the interpretation by the courts in both the second district and this district is that it's a family member. There's no other intermediaries that are included in the statute. So here we have Carr, Corrigan, and Weintraub getting the message before it goes to the judge. Plus, it wasn't sent directly to him. So in O'Leary, we have the message sent directly to a family member and received directly by a family member. That comports with the statute. This court should follow O'Leary and still vacate my client's conviction.
Counsel, there's another verb in the statute besides sends, and that's procures. And in this case, where your client, according to the evidence, your client went to the portal, not any county, not Pinellas County clerk portal or Escambia County, but Duval County, where it happens to be that Judge Meehan resides and works. Your client posted a note directed at the judge. And why is that not at a minimum procuring the sending of the message, where it has on the face of it, it's intended for Judge Meehan, and it's posted on a portal where it's likely to actually be sent to the recipient?
Well, Judge, I think it's too indirect. Even though he's in the courthouse, it's a complete separate entity. I mean, just because you're in the same building doesn't mean it's the same address. And even if that part is met, once again, if this court finds it's a threat, and if this court finds it was sent directly, it still wasn't received directly. The state is still failing in establishing that. There's still too many intermediaries before the judge got the message. And that's required by statute.
I'm sorry, you're actually in your rebuttal. I'll hold off on further questioning.
Thank you, Judge.
Sorry.
Thank you, counsel. Counsel for the state may proceed.
Thank you. Good morning, Your Honors. May it please the court, my name is David Welch, and I represent the state of Florida in this case. First, I want to briefly address the second part of issue 1, and that is the threat to do violence. As Your Honors have pointed out, previous district courts have stated that for a violation of 836.10 to occur, it depends on whether the message was sufficient to cause alarm in reasonable persons. And this is a jury question. So when you look at the message that was sent, it boils down to the appellant saying to the judge, I'm coming for you, I'm going to deal with you, I've got something for your ass, and make sure you tell the devil I said hello, without using his exact words. And even without the devil part, it's up to a reasonable person could interpret that I'm coming for you and I'm going to deal with you could be a threat of violence, but especially when you include the make sure you tell the devil that made you, basically I said hello, well it's very easy for a jury to conclude that I'm going to deal with you by killing you, so you make sure you tell the devil hello. And like Your Honors have said, that's a jury question, and when you make every inference towards the state's advantage here, that's enough to constitute the crime in this case. But then
counsel, on the question of alarm, which I have some trouble with that as the standard, because first of all, it's not mentioned in the statute. But moreover, there are instances, well, let me see if you agree with this. There are threats that could be made that don't involve bodily injury or death that could still be alarming to a reasonable person. Would you agree with that?
Yes, Your Honor. Like, for example, someone would threaten me to sue me. I could be alarmed that I'm going to end up in court.
Well, that's right.
So in this case, though,
or maybe it's extortionate or something like that, and it doesn't involve bodily injury or death, but it could implicate an interest that could be quite alarming to you.
Yes, I agree with that, Your Honor. And in this case, the alarm specifically would have to be the threat of death or serious bodily injury because of the language of the statute.
Sure. So which then gets us back to the question of how much is enough to constitute a threat of bodily injury or death, regardless of whether it's going to cause alarm in someone, in a reasonable person. It still has to be, there's a question of how much is enough. And is it your position that that's a question for the jury, and judges just have no business making a threshold call on that?
Well, Your Honor, I would say that there has to be some language that could be interpreted. Like, for example, if I just said, I'm going to sue you, and made a bunch of vague threats about taking legal recourse, I think a judge could make the determination, like, there's no way that a reasonable jury could interpret this as a threat of bodily harm or death. But as long as there's some language that a jury could interpret that way, then it becomes a jury question.
Thank you.
And moving on to the send-in, as appellant's counsel said a few times, the directly received, I would proffer that directly received is not in the statute, and using that line of interpretation, if I were to mail someone a threat, they're not going to directly receive it unless I hand deliver it to their mailbox, because it's got to go through U.S. Postal Service. You know, it's going to go through however many mail sorting centers, how many mail personnel, and then the mailman is going to put it in my mailbox. So even if I'm using the U.S. mail, which everyone would agree would be a way to violate this statute with a threat, it's not going to be directly received. The question is, was it directly sent, or did he procure the sending of it? In this case, the appellant utilized the clerk of the court's office, which is the portal to the courthouse. For example, when I go to the First District Court of Appeals website and it says, how do I want to, if you're going to file something, it's under the clerk's tab on the website. If a judge in a trial court says, counsel, I need you to send me this letter, or I need you to drop off whatever material, why don't you walk it down to the courthouse? If I were to walk down to the courthouse and try and go to the judge's office, I'm going to be turned away. They're going to direct me to the clerk's office to drop that record off with the clerk. And so because the appellant did not have direct access to the judge, because his email is not a public record, his address is not a public record, he used what he had access to. In this case, it was the clerk of the court's office. And as Your Honor already mentioned, he specifically used Duval counties because he knows that's where the judge was. And I think in his mind, the clerk probably was part of the entire judicial system. When you look at his message, he says to the judge and his administration before he goes on to threaten the judge. And when the detective went to his house and said, hey, did you send a message to the chief judge? The appellant's answer was, yes, I sent the judge a message. So he was under the impression that he directly sent the message to the judge, and he did it the way he knew he had access to, and that was using the website. And the other distinction I want to make is in appellant's brief, appellant discusses JAW, and the distinction there is JAW was talking about external factors. In that case, he posted a generic message about shooting up his school to Twitter. He did not tag the school. He did not tag any other people who went to the school or who worked at the school, excuse me. And then it was, in that case, third parties saw that message and independently forwarded it to the law enforcement officer agencies in that case, and to the school itself. And the court said, well, okay, that's too many steps because those are external factors. And I would note that at the time of this case, the statute had already been modified to criminalize posting a threat, a general threat to shoot up a school or commit an act of terrorism. Whereas here, it's analogous to sending a letter to through the mail, in that I've directly sent this electronic communication, and it's internal. All the people who handled this were internal to the clerk's office or the court system, went through whoever initially received it, and they followed procedure and forwarded it to courtroom security. And there's no reasonable way that if I were to send a threat to the courthouse, that security would not inform the judge that, like, hey, by the way, we've received the threat. This is so you're aware of this. And that's how the appellant in this case procured the send-in, and he directly addressed it to the judge. And
counsel, what if instead the defendant logged into the Escambia County clerk's office website and sent the same message directed to Judge Mahan, would that be a problem? I know that's not this case, but I'm trying to tease out how far out the procurement of sending can go and still satisfy the statute.
Potentially, I mean, it might depend on exactly what message. If he logs into the Escambia County website and says, I'm directly threatening this judge in this circuit, or this courthouse, maybe, again, because it's a hypothetical, it's hard to tease it out. But
Sure.
if you were to just say like, to Judge Smith, I'm coming for you, and make sure you tell the devil hello, there's probably a lot of Judge Smiths out there, and it would take, then we're potentially closer to JAW before the law change, in that you send out this vague threat that says, I'm going to shoot up my school without identifying what my school is. It might, in that case, you would potentially be in a situation where it took third parties to be like, hey, I know who this guy is, and I know what court he appeared in, so this is probably who he's talking about. In that case, it might be a closer question, but it would ultimately depend on the specific facts.
Well, counsel, also, I'll tease it out a little bit more in a different direction. Is it fair when considering a JOA motion, can the judge take into consideration more than just the message itself and consider all the evidence, the surrounding circumstances, including the defendant's statements made to law enforcement, in determining whether there's enough to go to a jury on it? Or does the judge have to focus on the statement itself to make that determination?
I believe the judge can focus on all of the evidence, but again, he has to make every inference in the state's favor. So in that case here, the judge could look at it and be like, well, this guy knows that, hey, this is a detective who's asking me, hey, did you send this message to the judge? It's in his interest at that point to downplay exactly what his message was. And so the judge could just rule like, well, okay, he knows he's being confronted at law enforcement. It's probably a lot better for him to say, I threatened the judge with a political consequences or lawsuit versus, yeah, I sent the judge a message. I want to make sure he goes to see the devil as soon as I can.
Counsel, assume for the sake of argument that the message was posted on the appellant's Facebook page rather than sent to the clerk's office. Would it have made a difference in this case?
Potentially, again, it would depend on with the way the statute reads now, and I believe it was changed a few months before this case occurred, and then has subsequently was changed. I think they added a second subsection about 2 weeks after this occurred. If the threat at that point was a school shooting or an act of terrorism, which potentially you could argue in this case that attacking a judge could be considered an act of terrorism, depending on the circumstances of it, because that would
assume for the sake of argument that the defendant posted the same message on his Facebook page that he sent to the clerk's office in this case. Would it have made a difference?
Potentially, because depending on what his Facebook friend group is, that's just generically posting something on your Facebook page now falls under the second half of the statute. Versus the directly send or procured the sending of. If one of his Facebook friends he knew was the judge's judicial assistant or maybe just an employee at the clerk's office, and they saw that, is that direct sending or not? Because they know that person's gonna, I've invited that person into my Facebook group, and now I am posting something for them to see. That way, I know that potentially it's going to get back to the judge. But in this case, that obviously is not the case because he had access to the clerk's and the jury services portal, and he posted it directly to the clerk of the court in the building where the judge works.
So, counsel, the circumstances then do matter to go back to my my hypothetical about the Escambia County clerk. If the same message were posted there, it would be the question would be not just did he procure, it would be under the circumstances, was it reasonable that whoever he was asking to do the sending would actually be in a position to do the sending? Or
yes, Your Honor, I agree. And obviously, as in any case, the circumstances obviously matter. And I think I borrowed a civil law term when I said kind of was him sending the message to the clerk's office the proximate cause of the judge receiving it? In this case, it was, because the security at the courthouse has a duty to inform the judge of threats received.
I mean, the jury, so to get back to the JOA standard, though, that I'm assuming it's your position that there was enough evidence in the record, certainly for the jury to consider whether what the defendant did here was procuring the clerk to send the message to the judge.
Yes, Your Honor. And as I referenced earlier, I would proffer that most people probably don't realize the distinction between the clerk's office and the judges themselves, in that, like I said, even as an attorney, if I'm going to drop something off for the judge, I'm going to the clerk's office to do it. So as a member of the public, they get on the website, they see, it's for the courthouse. Here's where the clerk, they have the judge's biographies on one side, but right there is the link to the clerk's office with the information on, like, if you're going to file something in your case, here's the address to send it to. And if I, a member of the public, walk up to the courthouse and say, hey, I have a filing for the judge, they're going to direct me to the clerk's office. And it's not going to be directly received. If I send a filing to the clerk's office, they're still going to look at it, because even if it's a perfectly legitimate filing with a court case, it may not be something that the judge is supposed to see. So it's going to, that's why the clerk will, and it's going to go through a security screening in the courthouse. I know it, if I get a letter here at the Attorney General's office, the mailroom opens it before it gets sent to my secretary and then put in my box for me to review. It's not directly being received by me, even if it's directly sent to me. So in this case, you send some, you write a letter to the clerk's or to the judge. It's still going to go through the clerk's office. It's still going to go through process, and then eventually, potentially, it will go to the judge. So even if I've directly sent it to the judge, it's not directly received by the judge unless I'm literally handing it to him or her. And unless there's any other questions, that's all I have for you gentlemen this morning.
Thank you, counsel. Ms. Jordan?
Reference to JAW, the court said, we hold that the plain and unambiguous meaning of section 836.10 requires a showing that the threat was sent directly to the potential victims or their family members. That was the holding, directly, based on the plain and unambiguous meaning of section 836.10. The legislature is well aware of how this has been interpreted by the courts, and they have had ample time to amend this statute if they wanted to say anything different. They've in fact amended it in 2010, they amended it twice in 2018, and the only thing they changed was the language about a mass shooting and terrorism. So the requirement is directly sent.
But did JAW consider procuring though? So what?
Yes.
Couldn't procuring to sending directly be the same, satisfy the same thing?
The court there said that, I'm sorry, go ahead, Judge.
For instance, so if sending means sending directly, procuring can't also mean sending directly, because procuring is something different.
Well, it said here that the procuring envisioned by the statute can't be stretched to include other intermediaries. So I would.
Well, who would you be procuring then, maybe, if there's not an intermediary?
Well, I would think a situation where maybe, I don't know, Judge, perhaps the language is poor in the statute, but maybe where the judicial assistant gets it or somebody closer to the judge. I don't know. All I know is the situation we have here is that it was not sent to the judge. It was sent to the jury services department. And even if it was sent to the judge or procured, it still was not directly received by him. There were too many people in between. And that is a problem that doesn't comport with the statute. And I believe the court can look into the totality of the circumstances. The Smith court made reference to that. It said that the courts actually should exercise caution in distinguishing true threats from crude hyperbole, because there's a language of dissatisfaction which is vituperative. I see my time is up. Thank you.
And thank you, counsel. This concludes our oral arguments for this morning. We stand in recess.
Thank you.